speech that will not soon be forgotten. Thank you very much. Let me move to Commissioner Jennifer Stoddart of Canada, who's been off in the news lately, concluding investigations of Facebook. Just a few days ago, my understanding is you entered into the Google Street View Wi-Fi issue as well. And I understand that earlier this month you were awarded the Privacy Vanguard Award for Leadership by the IAPP. Congratulations. Of course, we know her very well for her work at the OECD, which is, says in my notes, 2006, but Jennifer, it's got to be going back much further than that, I think. You've been leading our work on privacy for some time and providing a perspective around that OECD table that has been really very useful. So, Commissioner Stoddart, I understand that Canada's privacy laws adhere very closely to the OECD privacy guidelines. To what degree are some of the issues that Professor Rosen has just risen, those of remembering and forgetting issues, how are these coming up in Canada, and how do you think that we can address them?
I think I've got one. Thank you, Andy, for that question, and il me fait très grand plaisir d'être ici ce soir en Israël et de travailler avec mon collègue de l'ELITA, M. Hacohen. Aussi d'entendre le professeur Rosen avec son exposé fort stimulant sur les problèmes de la mémoire persistante. Interestingly enough, in reading your work, Professor Rosen, on this issue, I began to look more critically at the work that we're doing in Canada. And often it takes this kind of academic, I think, analysis to really make us say, well, what are we doing? And as Andy Wyckoff said, the OECD principles are very closely bound in to the Canadian private sector privacy law. And so I started to put together a couple of examples of things that we do already within that OECD framework. One of them that came to mind is that we dissociate publicly available information from the right to use personal information. So it's not because it's out there on the internet, or the example that you can look up on our website. It's not because it's posted on the internet in a bankruptcy case, for example, that a financial institution can take that information and use it basically against that person without his or her consent. So that, you know, with referring to the OECD guidelines, that just makes a very clear delineation between just being out there, being public per se, and the right to use it. Fortunately, that conclusion wasn't challenged in the courts, so that is the state of things. I could go on and talk about a whole series of cases that we dealt with complaints, very distraught individuals who would come to our office and say, well, oh, my friends are reading my name on the internet and they all know all the details of my handicap and the fact that I went back to try and get my pension adjusted last year. This was because some of our administrative tribunals in Canada were, without thinking, publishing in extenso all the decisions of administrative tribunals in very sensitive areas having to do with perhaps mental illness, unemployment insurance, things like that. So we went to the tribunals and we said, well, look, is it absolutely necessary for the open court principle, which really had to do with looking at who was rendering the justice, not looking at the details of the person who was receiving the justice, if you take it back to its original roots. And about 2/3 of these tribunals said no. In fact, we could just publish the names with X. We could just do a kind of resume of some of the details so that it wouldn't be possible to add to this person's, you know, growing CV when they're Googled all the details of their gastric complaints and their mental breakdowns for which they were getting state compensation. Anyway, I'll stop there, Andy, but that's an example of what we're currently doing and working on.
Thank you, Commissioner Stoddart, and I think it's a very useful kind of on-the-ground perspective of how some countries are dealing with these issues. We've talked a lot about the OECD so far, but thankfully, and this is another example of it, there are important discussions underway outside of Paris. Certainly these are happening in Brussels, where the European Commission is leading a review of the European privacy framework. we'll hear from the EC in the final session tomorrow. Another key venue is that of Washington, D.C., where this year there's been considerable reflection about the future of privacy, in part through a series that has been held at the Federal Trade Commission and the Department of Commerce. We're privileged tonight to have the General Counsel of the Department of Commerce, Cameron Carey, with us. He's been spearheading an Obama administration-wide effort to examine privacy and Internet policy issues. And it's my understanding, Mr. Carey, that the White House just announced a new privacy subcommittee across the administration that you are co-chairing along with the Department of Justice. Could you tell us about this work and address some of the points that Mr. Rosen has raised in his speech?
Sure, Andy, gladly. Let me say that our work proceeds from a couple of premises. One is that, taken as a whole, the United States has a strong privacy protective regime, rooted in our Constitution and a Fourth Amendment that, by its terms, protects places and things, but has been extended to a series of interests that deal with individual autonomy and individual privacy rights. You have overlaid on that a common law tradition, some of the tort remedies, property remedies that Jeff Rosen spoke about, and then a series of federal sectoral protections and a number of state laws dealing with data breach legislation and a number of additional privacy protections, and of course the Federal Trade Commission and the excellent enforcement work that it does, and then a strong set of self-regulatory mechanisms. So we believe that there's a strong basic framework, and that, taken as a whole, it is as strong as any omnibus system. At the same time, there's also, I think, a strong consensus that trust is critical to the continued value of the Internet as a cultural, social, and economic, and a political mechanism, and that privacy is a critical ingredient of that trust. And also, I think, in the process of the discussions that we have had, comments we've received, a sense that it's time to update that framework. So, while the fair information practices that were promulgated in 1970 for mainframe computing that sort of inform the OECD principles are well embedded in the system, we're at a point where there is more to be done. So our effort, you mentioned the administration's interagency committee. That's an effort to come forward with administration views that on these issues, to address legislation that is moving forward in Congress. That's going to be informed by work that the Department of Commerce has done through our Internet Policy Task Force, which is looking broadly at the ecology of the Internet, privacy,